Chances are good that when you were a young kid, your parents offered you rewards if you performed good deeds, like cleaning your room. All you had to do to accept the offer was to perform the chore. But in the legal world, can courts presume that performance constitutes acceptance? The Delaware Supreme Court addressed this issue in the 1971 case of Industrial America Incorporated versus Fulton Industries Incorporated. Bush Hog Incorporated was a farming equipment company that wanted to merge with another company. Bush Hog hired Industrial America Incorporated to facilitate a merger. Industrial failed to complete a merger. Bush Hog decided to end its work with Industrial, but didn't inform Industrial of its decision. Fulton Industries Incorporated placed an advertisement in the Wall Street Journal seeking a merger with another company. The ad indicated that brokers were fully protected. Industrial saw the ad and reached out to Fulton with details about Bush Hog. Fulton expressed interest in Bush Hog and asked Industrial to set up a meeting. Fulton's president contacted Bush Hog directly to set up a meeting. Fulton's president didn't inform Industrial of the meeting. Fulton and Bush Hog ceased communications with Industrial. The two companies eventually completed the merger. Industrial sued Bush Hog and Fulton to recover a broker's commission. The trial court found in favor of Industrial and awarded Industrial the $150,000 commission against Bush Hog. The trial court didn't grant a commission for Industrial against Fulton, reasoning that Industrial didn't accept Fulton's offer in the ad. Industrial appealed directly to the Delaware Supreme Court.